Now, I know a lot of you are very interested in the law surrounding freedom of expression and especially free speech. So I've got what I hope is quite an interesting one for you today, but it's because it concerns what free speech rights do barristers actually have. So what am I talking about? Well, Dr. Charlotte Proudman, a barrister, she is being prosecuted by the Bar Standards Board for some comments she made about a judge in a particular case. And we had a preliminary hearing, what we call a strikeout application, last week that raises some very interesting points. So I thought I'd like to talk about that specifically and maybe some just more general points. First of all, I need to declare an interest. Charlotte is both a Chambers colleague and a friend, and also a fellow Northerner. But I will try to be objective about this. And to assist with that, what I'll do is, in the description, I'll put a link to the judgment of the tribunal and also a link to the original case that she was commenting on. So what was the case? She was acting in a family dispute because, you know, she's an expert in family law. And she was acting for the wife in a particular hearing. And, you know, as often in these cases, there were allegations of, you know, abuse, to put it mildly. The judge, however, he found that actually, while it was a volatile relationship, it didn't cross the threshold into abuse. And, you know, you can read in the judgment yourself as to sort of why he came to those conclusions. However, the husband in the case was himself a part-time judge. So Charlotte put out a series of tweets commenting about the case, saying that she disagreed with the conclusions and suggesting that perhaps the judge was influenced effectively by being a member of the old boys network, that this was sort of male judges, male lawyers, just, you know, all looking after each other's interests. And for that, she now faces the tribunal. So just to explain how this works, the Bar Standards Board is our regulator, and if they think a complaint is founded, then it goes off to the Bar Tribunal. So the Bar Standards Board is in effect, although it's our regulator, when something gets this far, they effectively act as the prosecutor, and it all goes before the tribunal. But there's a preliminary hearing, and Dr. Proudman applied to strike out the prosecution generally. And she did that on a couple of grounds. And effectively it was that she was being discriminated against because, first of all, a number of male barristers had, first of all, just commented about her generally, including publicly using the C word to describe her. And the Bar Standards Board didn't even take it any further. They just dismissed the complaint outright and said, no, everybody's got freedom of speech, so that's perfectly permissible. But also on the ground that lots of other male barristers have been very critical of the judiciary and individual judges, and they haven't been proceeded against. She also argued that she was being unlawfully discriminated against because of a protected belief, that is to say, feminism, because, you know, Charlotte's a very proud and self-professed feminist. And just to explain what protected beliefs are, in law, you know, some beliefs are protected. That's like religious beliefs, but also philosophical beliefs. Not so much political beliefs. Political beliefs do have protection, but not to the same extent that philosophical beliefs are. I mean, essentially, it has to be a belief that you just internally, you know, innately feel in your heart. It's not necessarily one that you've arrived at sort of, you know, logically. You know, so if it's politics, you might say, well, I prefer this party over this party because I think they've got better policies on this or different policies on that. You know, that's a rational decision. You've put, you know, there's a reason behind it. But obviously, you know, with things like religion, you just, you know, generally speaking, you just believe it or you don't. And it's the same for philosophical beliefs. I mean, veganism is a protected belief. I had some small involvement in that case, Georgie Castamata. Maybe I'll do a video on that one day. But if a belief is protected, then you have a right to hold that belief. You have a right to express that belief, to say, yes, This is the belief I hold. And you also have certain rights to manifest that belief, although they are limited. So say, for instance, your religion requires human sacrifice. Well, you're allowed to say, I'm a member of this religion, and I genuinely believe this, but the law can say, well, hang on, you can't really manifest, we put some limits on the manifestations of your belief. And the argument here is that, yes, okay, we accept feminism as a protected belief. You can hold that, you can declare yourself, but that doesn't mean that the mere fact that you are penalised for the way you manifest that belief is necessarily discriminatory. So she applied for the strikeout. Now, the first thing to note is this application was heard in private. No journalists or public were allowed in. Now, that is the normal procedure for these things. The normal procedure is that preliminary hearings, like directions hearings, are just heard in private, but the main hearing is heard in public. However, the judge has a discretion to alter that. So the judge can say, it's a preliminary hearing, but I'm going to allow it to be heard in public. And there are a number of journalists there, obviously, because this is quite a big story, but they weren't actually allowed to make representations, because their argument was, look, there's a public interest in this, we should be allowed access to report on what happens. But they weren't actually even allowed to make the arguments that they should be. Now, I understand that one of the reasons for that was the judge said, we need to protect the privacy of the other barristers that she's comparing herself to. Now, again, I'm going to express an opinion here, so when I go off my objectivity, I mean, if this is correct, and there's a journalist called Louise Tickle who does a lot of work on, the secrecy of courts, and especially the family courts, and, campaigns for open and transparent justice. So, if you want more details, maybe sort of like check her out, go on Twitter and see what she says about this. But apparently one of the reasons was, it's not fair on the other barristers that they are named. But the counter-argument to that is, well, hang on, they've made public pronouncements. You can just go on Twitter and see what they said. And also, you could argue and say, well, if you want to protect their privacy, we can do it the normal way, because you could just say, Barrister A, Barrister B, Barrister C said the following. But anyway, the hearing was in private. However, we now have the full judgment, and also been able to see some of the, the skeleton arguments from both sides. So although I don't particularly know what was said in court, we can look at what arguments were put forth. So those were Charlotte's arguments, that I am being discriminated against because I am being treated differently from male barristers who've pretty much done the same thing. So she raised an Article 6 challenge. That's under the ECHR. Article 6 is your right to a fair trial, and also an Article 14 challenge. Article 14 is the right not to be discriminated against because of a protected characteristic, such as being a woman. They also say that that's actually parasitic on another right, so it's not a freestanding right per se. You have to attach it to another right. I have a right to a fair trial. I'm not getting a fair trial because you're treating me differently. The Bar Standards put forward a very interesting argument. They effectively said it doesn't really apply in our particular cases and even if it does, it only applies to your right to due process, not to whether we prosecute you in the first place. They said the tribunal can't even, as a matter of law, consider the human rights arguments. Now, it's fair to say the judge didn't find that a very attractive submission, because he pointed out and said, on the Bar Standards Board argument, it would be, if you said to, say, a black defendant in a case, you only get 5 weeks to prepare your trial, everybody else gets 10 weeks, all the white people get 10 weeks to prepare your trial, they say, yes, that would be discriminatory, but if a body said, we only prosecute black people, that wouldn't be discriminatory, because the argument was, the BSB's argument was, it just applies to the due process element, not the actual substantive fairness of who gets prosecuted in the first place. So the judge dismissed that argument. He wasn't very impressed with it. But what he said was, well, look, I'm not going to strike out the case now. However, this is a matter that can be dealt with in the full hearing. Now, the Bar Standards Board objected to that because they said by having all these complex legal arguments, that puts a big burden on them. It will mean the hearing has to be at least 4 weeks long. I mean, the judge said, well, no, it doesn't, because it's all on paper. There might be a couple of witnesses, but basically there's just going to be lots of reading of people's tweets and comments. So that can all be done pre-reading. And again, just to put my own opinion in, and don't get me wrong, we've had, the BSB on on Dan's channel. I mean, I go to the BSB round table meetings. I don't have any real problems with the BSB. I don't necessarily agree with everything they do, especially the regulatory burden they put on us. I mean, I've got a big interest in, sort of like the social, social media aspects and the freedom of speech aspects, because obviously, heart on my sleeve, my animal rights stuff. So I do follow that. But I did find it a bit ironic that one of the complaints we always have about the Bar Standards Board is they always dump loads of regulatory stuff on us. There's a new one they want to do now where they want to change the code of conduct, the handbook, to say we have to have a positive duty not to discriminate, as opposed to currently there is it's an offence under the handbook to discriminate, and they say no, you've got to have a positive duty to promote equality and inclusion, which very laudable goals that I completely subscribe to. But the argument is you're dumping more regulatory stuff on us, you put enough stuff on us, so it's a bit cheeky now to say, oh, this will create loads of paperwork for us doing this hearing. But like I say, the judge has pretty much dismissed that and said no, we're going to have this hearing. So who won the hearing? Well, it's an interesting one. I suppose, arguably, the strikeout application was not successful. However, the judge has said, it's not that I disagree with the points you are raising, I just think that they should be dealt with at the main hearing. I mean, it's always worth, I say it's always worth applying to strike out something early on. Funnily enough, I've just had a case this week where I made a positive decision not to apply for a strikeout and summary judgment, because when you do that, there's more of a burden on you, because you've got to prove that the case either is wrong as a matter of law, or when you look at all the facts, you would win anyway. And the way they do it is they always say, whoever's making the application, let's assume that everything the other side say is true. So it's like, so your argument is, even if you believe everything they say, we should still win. So that puts quite a high burden on you. I'd rather it was a trial, where it's like, it's for the other side to prove it. And that's going to be the same thing in this hearing. It's going to be for the Bar Standards Board to prove that Charlotte's comments went too far. But there you go. I mean, I just thought you might find that interesting, because it brings in all sorts of aspects, how the courts work, what's the limits of comments. I mean, back in my student days, there's a really popular book by Jagger Griffiths, The Politics of the Judiciary, that went into, where do judges come from? What are their backgrounds? And the argument was everybody's a product of their upbringing and their environment. So judges would have, implicit biases just because of the pool that judges are recruited from. So it's interesting, academics are always allowed, it's always been a point to comment on whether the judges, are fair. I mean, the makeup of the judiciary is changing now, but the judges themselves, we have this judicial compendium, the bench book, which warns judges about, implicit biases. And we do lots of training at the bar. I've done lots of, I've done all my implicit bias training. I like to think all my biases are, really explicit. Carnists. But yeah, there is this argument about sort of, is it legit to comment? I mean, the counter argument is, judges don't have a right of reply. So it's not really fair to criticise judges, because they can't come back and say, well, no, that's just wrong. So the argument is, you do it all within the legal proceedings. If you're unhappy with a decision, then you appeal it and you see what the relevant appellate court says. But we have come on a long way from, criticism of the judiciary. I mean, I remember back in olden days when UK.legal was a thing, a particular person got in trouble for, quote, scandalising the judiciary. And, and the court there said, that's not an offence these days. They said the best way to deal with, such criticism is perhaps just a wry smile and a raise of an eyebrow. Judges are expected to have very thick skins. But then there's also the argument that as lawyers and as members of the bar, we're held to a higher standard, and part of that is not bringing the entire legal system into disrepute. But again, you know, lots of lawyers do campaign about the legal system generally and campaign for changes in the law. I mean, we do it with all our, so again, our animal rights stuff. I've been involved in a few things. I say involved. I mean, involved is doing a lot of heavy lifting there. But, you know, we've assisted people, or rather my cleverer colleagues have assisted people in getting changes to the law. You know, with the Animal Sentience Act, we managed to get decapods and cephalopods recognised as sentient. So, you know, that was heart on the sleeve stuff. And in all fairness, you know, we didn't really get criticised for that. You know, you get people coming up to and eating bacon sandwiches in your face and things like that, but that's, you know, that's not really a big issue. It's not like we've got any official sanction. So yeah, it's a very wide issue, this. And like I say, I'd be really, really interested in your comments about this. One thing I would say is, I know Charlotte's a very controversial figure, but like I say, she is a mate of mine. So comment on the case, not the personalities. I mean, I do genuinely want to hear what you have to think about, you know, should we be held to a higher standard? Should barristers keep stum? You know, were the criticisms fair? I mean, like I say, I'll link to both judgments so that you can form your own opinions. And I'll be very, very interested to hear what you have to say on this. And obviously, now this is going to a full hearing, I will obviously report back on what happens there. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely informative, vaguely accurate. Where am I today? As always, when it's a nice day, I've just come up to Pentyre stroke Pentyre again because it's a lovely, lovely spot, and also I can pop off to the Lewinick to edit this while drinking their excellent coffee. This is not a sponsored video, by the way, although Pete, if you are seeing this, I'll just point out that your chips are rather nice.